So, without further delay, I'm going to introduce Sheriden Barnett, who's the principal of the Boreal Center for Dispute Resolution. Since 1988, Sheridan's worked across the country with federal, provincial, territorial, and First Nations governments to resolve historic treaty, land claim, resource development, and human rights disputes, including a convener and mediator for the inaugural treaty discussion forum between the Anishinaabe Nation and Canada. As founder of the Boreal Center, Sheriden provides expert advice and dispute resolution services to resource development companies, First Nations, and governments at all levels. Sheriden studied extensively in the areas of Aboriginal history and law, principled negotiation and multi-party consensus, mediation and cross-cultural peace building, both internationally, at the internationally recognized International Conflict Research Institute at the University of Ulster and the Osgoode Hall Law School at York, where she earned a Master of Laws in 2004. In January 2013, Sheriden joined AIM-BC as the Senior Director of Aboriginal Relations and Land Use in Vancouver, where she was instrumental in the development of AIM-BC's recently published Aboriginal Engagement Guidebook, which I think she's going to talk about, at least what happened to it after Chilcotin. Sheriden Barnett.
Well, good afternoon, everybody. My name is Sheriden Barnett, and thank you very much for the introduction, Bill. The topic for my presentation today is entitled A Practitioner's Guide to Aboriginal Engagement for Mineral Explorers in Canada. As Bill just mentioned, I just came back from BC, where I was the lead staff person on the development of the Aboriginal Engagement Guide, which was a principled and practical approach. And I'm not going to be speaking about the guidebook specifically, but if you're interested, it is on AMEBC's website. But I will be speaking about some of the pieces that I contributed to the development of that, and specifically around principled and practical guidance for Aboriginal consultation in Canada. So my perspective, just to build on what Bill has said, is shaped by my involvement of probably 20 plus years with First Nations, federal and provincial governments, and as also a researcher, analyst, a negotiator, and a mediator of land claims, treaty, and resource development disputes. So I kind of have a bit of a rounded perspective. I don't come from really one frame of perspective or one frame of view, and so I'm hoping that what I'll have to say to you today will be useful to you. I was providing advice as well as part of an industry association, both at the PDAC and AMEBC over the last 4 years, and providing advice on regulatory and legal issues as well as Aboriginal consultation matters to the industry. So I've just realized that we're not only speaking to folks who are residing in Canada, working in Canada, but we're also speaking to some international folks who are joining us on the web. So I think this introduction is really for you. For those of you who are not otherwise aware, Canada does have a rich history of treaty making and reconciliation of the rights and interests of Aboriginal peoples, including First Nations, Inuit, and Métis. That reconciliation is with the interests of the broader public society. More recently, this history of reconciliation has evolved into legal, regulatory, and social license expectations that proponents, specifically here of mineral exploration, play a procedural role in discharging the Crown's duty to consult and accommodate those Aboriginal peoples who are affected by resource development of any kind. We generally refer to proponents' involvement in consultation as engagement, and I'm just letting you know that because the terms engagement and consultation are often used as a similar thing. But when I'm talking about the duty to consult, I'm speaking about government's duty. When I'm speaking about engagement, I'm speaking about the role that industry can play. So this presentation will provide a practical and a principled approach to the mineral explorer who's searching for a roadmap to conducting effective Aboriginal engagement. The scope of the presentation will answer the following questions. What is the current state of play for Aboriginal engagement in Canada? How have the recent legal decisions, specifically the Chilcotin decision out of BC in 2014, changed the landscape of Aboriginal consultation in Canada? What are the roles and responsibilities of the mineral explorer and developer in engaging Aboriginal peoples who may be affected by exploration activities? And what is in the best why is it in the best interests of proponents to engage meaningfully and effectively? The bulk of my presentation will be on the final bullet, which is what are the key principles and practices that may be applied by mineral explorers and developers to navigate the complexities and challenges that arise when engaging potentially affected Aboriginal communities. So, moving into the bulk of the presentation. Everything okay?
Yep.
Chilcotin Nation versus British Columbia is a June 2014 decision of the Supreme Court of Canada awarding Aboriginal title to the Chilcotin Nation over their claimed traditional territories. This is the first declaration of Aboriginal title lands in Canada. Many others are expected to follow. So why this is different, Aboriginal title as a concept has been recognized in Canada for a period of about 30 years, starting with the Calder decision. It was enshrined in 1982 in the Constitution. But this is the first actual designation of a specific territory as being held by Aboriginal title holders. We'll talk about why this is important. Aboriginal title has been defined then by the Supreme Court of Canada as ownership rights similar to those associated with fee simple, including the right to decide how the land will be used, the right of enjoyment and occupancy of the land, the right to possess the land, and the right to the economic benefits of the land. Also the right to proactively use and manage the land. And I believe this presentation will be available to anybody who's interested in dwelling on those sentiments. Further, the slide. The title holding group has the right to choose the uses to which the land is put and to enjoy its economic fruits, provided these uses can be reconciled with the group's communal and ongoing nature of the group's attachment to the land. So there's constantly a balancing act that the courts are trying to attain, both between the rights of Aboriginal peoples versus the rights of the broader public society, but also within the rights of Aboriginal people and the rights, the ongoing communal rights of the title holders themselves, of the Aboriginal group themselves. So there's a constant balancing act that's happening. Governments and those seeking to use the land must obtain the consent, yes, I'm using that word, of the Aboriginal title holders or justify an incursion justified by a compelling and substantial public purpose subject to the Section 35 Constitution Act, protection of Aboriginal rights. So you know, as a lawyer in the room, if you're a lawyer in the room, you can kind of unpack that. But the trigger word here is consent. And what essentially the Supreme Court is saying is that for Aboriginal title lands, where Aboriginal title has been proven, the requirement is consent of the Aboriginal group that you're dealing with. And that's specifically for government, but also something to be aware of as a proponent out on the land. You know, what we're talking about here is obtaining agreement. We're talking about obtaining agreement when negotiating with the Aboriginal group. I'm going to talk a little bit about where the potential for Aboriginal title exists as well, not just where proven Aboriginal title exists. Where a claim of Aboriginal title exists but has not yet been proven, a sliding scale of consultation and accommodation proportionate to the strength of the claim. Do I need to do that? Yep. Sorry, thanks.
Oh, did too fast. Two? Got it. Nope.
Thank you. Is that it?
I did it when we're fighting. So.
Being very helpful, Bill. Thank you.
Stop now.
So let me start again. Where a claim of Aboriginal title exists but has not yet been proven, a sliding scale of consultation and accommodation proportionate to the strength of the claim and to the seriousness of the impact on the claimed rights is required. Governments and individuals proposing to use or exploit the land, whether before or after a declaration of Aboriginal title, can avoid a charge of infringement or failure to adequately consult by obtaining the consent of the Aboriginal group. So in English, that just means that whether you're dealing with proven Aboriginal title or the potential for Aboriginal title, the court is recommending that you negotiate an agreement. You obtain the consent before entering the land, before mineral title or mineral tenure is being awarded, and also before doing any activities on the land. Issuance of timber licenses on the Aboriginal title lands, and this is specific to Chilcotin, which is the direct transfer of Aboriginal property rights to a third party, will plainly be a meaningful diminution in the Aboriginal group's ownership right and will amount to an infringement that must be justified absent Aboriginal consent. So again, what does that mean? That means that the issuance of in this case forestry licenses, but I mean it would conceivably equate to the issuance also of mineral title. Is considered a direct transfer of Aboriginal property rights to a third party and therefore requires consent. Okay, so we're talking about pre-mineral tenure consultation here. So that's really what I have to say about the Chilcotin decision. I'm going to talk now about how does this apply to consultation and engagement. And I mean, for those of you, and I forgot to ask you the question, but how many of you are either working or want to work in BC? Are any of you doing that? Okay, we've got one gentleman. I don't think you're being videotaped, so. Okay, how many others are looking at doing work in other areas of Canada that may be subject to Aboriginal title? And I'm talking here about, you know, the Maritime provinces, north of 60, parts of Ontario, Quebec, so basically the rest of Canada. Anybody else? Yeah, okay. So it does apply to you, and I just wanted to make sure that was clear. Okay, I've got 10 minutes left, so I'm going to move forward here. I had a slide on the duty to consult, so we're talking specifically about that graduated approach, right, to consultation and engagement, where we're not talking about Aboriginal title lands, but we're talking about treaty rights and Aboriginal rights, which is another level of constitutionally protected rights. So we have Aboriginal title, which talks about ownership of the land. Then we have Aboriginal rights and treaty rights, which flow from either specifically signed treaties, historic or modern, and then we have Aboriginal rights, which are essentially cultural rights, hunting, fishing, gathering, etc., that occur over a course of a traditional territory, or potentially a mixture of multiple traditional territories. So you have sort of three layers of rights that you need to be identifying, and the duty to consult obviously applies to all of them. This is just a slide that talks about the application to treaty lands, the Mikisew Cree decision, and the court ruled that even though the treaty allowed for the taking up of land, for the example for the settlement trade or lumbering, etc., that the Crown still had a duty to consult and accommodate treaty rights throughout the surrendered lands. For most of us in this room, this is already known, but for the fact that we have people calling in from other parts of the world, it may just help to go across this. So there's also the duty to consult, which is independent of treaties. Little Salmon Carmacks First Nation versus Yukon. The court determined that the duty to consult and accommodate exists independent of treaties and applies in the interpretation of treaties both modern and ancient. As a result of this case, there's no part of Canada that is not subject to the duty to consult with and where necessary accommodate First Nations, Inuit, and Métis. Okay, I'm going to skip over the plot next decision, I think, because we have Ontario-specific information that's going to come forward on that. I'm going to skip over to why engage because I've only got about 8 minutes left. So there is I think most of you in this room understand why you need to engage with First Nations and Aboriginal peoples, right? But just let me restate it for the record. So, you know, while the legal duty to consult exists and lies with the Crown, whether it be federal or provincial, the reality is that the Crown is able to delegate responsibility to gather and share information with First Nations to the industry proponents. So we call that the procedural aspects of consultation. But it's information sharing that's required. That then helps to substantiate the duty to consult has been concluded. There's a strong business case as well for early and ongoing engagement with Aboriginal groups potentially affected by mineral exploration or development. Engagement offers a competitive advantage that enhances the ability to attract investment, decreases project risks and legal expenses. Agreements provide certainty, and I'm speaking about agreements here, as well as the consultation or the engagement process. Agreements specifically provide certainty for a project, reduce risks of litigation and opposition resulting in permit and other approval delays. I'm going to move on now to the principles for engagement, which is sort of the meat and potatoes of my presentation. Okay, so while the principles of engagement, so respecting Aboriginal and existing Aboriginal and treaty rights. I framed that specifically because that's the statement that's included in the in Section 35 protected rights. And what does that mean to industry? I mean, it's not industry's role to assess or determine what an Aboriginal or treaty right is, and yet when you're out in the field and you're working in Aboriginal traditional territories and potentially Aboriginal title territories, you need to understand that existing and proven rights are something that that you need to be cognizant of, respectful of at all times. That you're not a decision maker, but you are working within a framework that exists. And that it's not your role there to determine whether or not certain Aboriginal or treaty rights are valid. Okay, so you're dealing with what is being expressed as an existing or Aboriginal treaty right. You can consult with government, obviously, because government, usually provincial, often sometimes federal, has the information about the treaty rights or the Aboriginal rights that are being claimed, the level of validity of those claims, but we always recommended that you actually specifically speak to the Aboriginal communities that you're going to be engaging with and obtain their perspective on their Aboriginal and treaty rights. Identifying potentially affected Aboriginal communities. You know, in mediation and negotiation, we often say that one of the most difficult things is identifying who the parties are, and I think this is specifically true of Aboriginal engagement. You can have, obviously, you want to check in with the government that you're working with in order to identify the potentially affected local area communities. But the analysis shouldn't stop there. You should be speaking to the communities themselves to find out who may be potentially affected within the traditional territory that you're working. And even if there's conflicting information, follow those leads and make sure that you're understanding fully who might be affected, not just who's being coming to the table first. Building area and community profiles. You know, I think this is particularly helpful if you're looking to take on a mineral property, maybe prior to applying for mineral tenure, or if you're looking to take over another company or a property. It's really important to understand sort of what the existing relationships are, what the existing attitudes are towards resource development, mineral development, exploration specifically, in order to understand what you're going to be dealing with, right? Because you have multiple choices. Unless you already own a property, we're talking about before you acquire it, you have multiple choices as to where you're going to invest your money, and you want to make sure that you're going to be investing your money in an area that's more likely to be successful. We know there are certain areas within, you know, provinces and territories that are absolutely no-go zones. I could probably name 3 of them in BC right now, and several in Ontario. So going in and knowing that before you acquire a property, I think, is a very important thing. If you're dealing with an unknown area or unknown First Nation, do your research, right? So look at any kind of do a media scan, do a legal scan, talk with the government, make sure that you understand any treaty disputes or land claim disputes or Aboriginal title issues, and really do that analysis in order to determine, is this a place where I have a hope of developing a positive relationship, or am I trying to do a project in a traditional territory, particular area that is considered sacred, for example, where there's absolutely, regardless of the profile of the community, there will be no chance of having a development. Overlapping and shared territories. So this is a big one, right, for folks working in Canada, because obviously Aboriginal territories are historically can be overlapping. There's also exclusive use, but there's often shared areas. There's also sometimes disputes as to which First Nation has rights in a particular area. And I'm just looking for my notes on that one. But essentially, the advice there is to identify any overlapping or shared territories. that may require the explorer to engage with more than one Aboriginal group at the same time. Okay, that's typical of many properties. Aboriginal groups who have recognized that they historically shared territories may have protocols in place that spell out the engagement or a consultation process and how any benefits from resource development may be distributed. So that's your best case scenario. However, navigating overlapping claims, traditional territories where the Aboriginal groups are not in agreement about historical use can prove more challenging. Remember that the trigger for the Crown's duty to consult is low, and that the Aboriginal group does not need to have proven their rights or the exclusivity of those rights in order for consultation to be required. It's typically better to err on the side of being more inclusive and equitable in determining which Aboriginal groups to engage with. Obviously confirm with government prior to engaging any groups that the government has not previously advised should be consulted, but also go with your research, right, your community-based research as to who the potentially affected Aboriginal communities are. So in addition to seeking advice from government, you should seek out perspectives from the Aboriginal groups themselves directly at an early stage, as they may have relevant information about historic or developing claims. Be careful of accepting one party's views or claims as absolute or exclusive, particularly if there's evidence that others should be considered and consulted. Avoid making exclusive arrangements at any time in the engagement process. In the case of multiple claimants, approach the matter in a transparent and respectful manner, obviously with Aboriginal groups. Just 1 minute? Really? Oh, okay. Whoops. So on that note, I just want to talk a little bit about cooperative research, right? Cooperative research and cooperative engagement processes, because I think that's something that's pretty underutilized in this industry. But where you have multiple companies working in a particular area, traditional territory, and you maybe have multiple communities, right, who are potentially affected by those projects, there's lots of information that can be shared if it's negotiated up front. And you know, this is a cost savings, but it's also, it just gets to the heart of ensuring that environmental impacts, cultural impacts are mitigated. And also in terms of making sure that the people who need to be involved in the agreement process and in the decision-making process around the project approvals and whatnot are actually involved in a way that is helpful rather than a hindrance. And I meant to say more about that, but given the fact that I don't have any more time, I think I'll stop there. So thanks for your attention. The rest of my presentation is available, I think, as part of the TGDG website. So do we have time for questions, or is that it? Keep your question for the end. We're going to be taking all the questions at the end. Thank you very much.
Okay. Is that something companies are doing right now, talking to each other about their Aboriginal counterparts? No? Okay. Some places. Oh, thanks.
Very quiet.
Very quiet. All right.
And then in terms of research, not agreements.
Okay, research. Well, that's a good distinction, actually. Yes. That's okay. So I just want to thank you, Sheriden. As Sheriden mentioned, her presentation, the full presentation will be available through the TGDG website for this symposium.